Okay, are we basically in? People in? The first question is about to hit. It's waiting, waiting, waiting. I think there's basically 30 seconds for each question. Which of the following is an acceptance? You should be able to see, and I'm going to try and play with this in the meantime. Okay, clearly it doesn't move on by itself after the number of seconds. 17 of you are in. And 78% of those who responded got the right answer. Do we need to have a discussion about what an acceptance is? So the options were, so nobody said any indication that the offeree is prepared to negotiate. 78% of you said a final and unqualified assent to the terms of the offer, despite the fact there was a typo there. Kahoot didn't work, it wouldn't let me save, and so I did this new version in this untested software on the run and on my phone. So I clearly couldn't see when I wasn't, so there's just going to be, today's going to be one of those days where shit goes wrong. See, and I just swore in the classroom, so there's another thing. Just add them to the list. Let's see how many we get. What the purchaser does to confirm willingness to purchase could in fact be an offer, but is probably not an excellent definition of what an offer is. Okay. Yay. How cool is that? My L Super Cheapo AliExpress multi-converter works, and the shiny, beautiful one that they attach here so that we don't steal them does not. That's all it was. So what the purchaser does to confirm willingness to purchase may in fact be an acceptance, but it's not a definition of what an acceptance is, and will depend on the facts of each case. Again, is an absolutely correct statement, but we have a better definition in that pile of what an acceptance is. We have a leaderboard, and oh, that's quite fancy, isn't it? Okay, we'll just see what happens each time. This is new to me. I haven't used this software before. I like it better because it lets me put more words in. Who can accept an offer? Let's have a look at the options. Generally, only a person to whom the offer has been made, any person who is aware of the offer, the highest bidder, or anyone with capacity to contract. Doesn't play music though. Do you want me to sing? Do dee do dee do do dee do 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 do. I told you wouldn't want me to sing for long. 7 seconds to go. There's reward for speed as well as accuracy, and your time is up. Oh, it locks the poll. Okay, so most people got this one wrong. Let's have a look. Anyone with capacity to contract. So, yes, a person who accepts an offer has to have capacity to contract, but they also need to be a person to whom the offer was made. Any person who is aware of the offer can also accept an offer if that offer is made to the world at large. But if the offer hasn't been made to them, then they possibly can't accept. So again, I have included in here the type of person, the second requisite, and we talk about capacity in a few weeks' time. So in order to make a contract, the parties need to have capacity. But in order to accept an offer, the offer has to be made to you. Questions, concerns, frustrations, compliments on my singing? Yeah, that was never going to happen. Leader has changed. Oh, a little bit of fussing around there. Lizzie is the one to beat. Can an act done in ignorance of a unilateral offer be acceptance of the offer? Please read that to be the unilateral offer. The act done in ignorance of a unilateral offer be acceptance of that unilateral offer. Yes or no? You're looking quietly confident there. I should count how many of you there are in the room so I can flick forward if it gets full. Okay, most people got that wrong. This is very educative for me, you see, because it helps me focus my attention and my focus. So let's unpick this one. An act done in ignorance of a unilateral offer. Not particularly plain language question. Another way of framing the question might be, if you didn't know that a unilateral offer had been made, could you accept that unilateral offer? Let's think of some scenarios where that question might be true. Poster on the fence, reward for lost cat. Somebody finds that lost cat but knows nothing about the poster, uses the little chain around their neck to determine who the owner is, or maybe takes the cat to the vet and they have one of those microchipping things. They contact the owner, hand over the cat, still in complete ignorance of the fact that there's a sign on the fence saying reward for lost cat. Does the person who owns the cat have to give them a reward? They might anyway, but don't really understand why you would, if you had a cat, want to give a reward in the first place. But just say, do they have to do it? If there's a contract formed by the doing of the act for which the promise has been made, so a unilateral contract would include the publication of the if you do this, then I will pay you this amount of money. That is a unilateral offer. Okay, it's a unilateral contract. We know from last week that a unilateral contract is made at the point in time where the offeree does the thing that's required by the contract. I'm going to try. Fabian?
Yeah, very good. My understanding from the readings, maybe I'm completely off on this, because I did brush through it a little bit.
Hopefully you are. Do you know, no, quite seriously, I really hope that you are completely off, because the worst thing that can happen to me is that you have the right answer first go. Because I've got absolutely no idea then whether you understand why it's the right answer or whether everybody else in the room is as smart as you or not. So I'm hoping, there's no reason for me to suspect that you don't know what you're talking about, but I'm genuinely hoping that you're going to really blow it right now. No pressure.
There was a case of, which I forget the name of, where a guy accused of murder.
How do we say it?
Queen and Clark, or Regina and Clark.
Crown and Clark. Crown and Clark, yes, thank you.
Yeah, the details of which he was accused of murder. He eventually got off by giving evidence against someone else.
Yep.
To reward out for the arrest of the person who did the murder.
Absolutely.
Arrest and conviction, I think.
So it's basically, if you help us with our inquiries,
Yes.
then we're going to give you a lesser sentence.
Yes.
And it turns out at the same time, reward poster.
Yes.
Yeah.
And it ended up being that his evidence got someone else convicted, and then he tried to claim the reward, even though he didn't know about the reward until that conviction was overturned or put on the other.
And so what happened?
It was denied, wasn't it?
It was denied.
Yes.
See, what really sucks about that is you are entirely on point, and it's an excellent example. It is a unilateral contract.
Yeah.
So there were two different potential contracts that were going on there. So one is, and if you help me with my inquiries in consideration, so the price that we'll pay for that is a lesser sentence on the thing that we've nabbed you for already. So there are a few different contractual theories going on here, but in relation to this question, that case is the perfect authority for the proposition that if you don't know about an offer, in a unilateral offer, then doing the thing that would otherwise create the contract is not enough. You have to do the thing in consideration of the offer of the reward. So how does this gets tricky with Carlisle and carbolic smoke ball though, doesn't it? Because do you think that Mrs. Carlisle only took the smoke ball, like inhaled this chemical or whatever it was, every day, 3 times a day for 2 weeks or whatever the instructions were on the pack, in the vain hope that if she got the flu, they'd give her 100 quid? Like, is that what she was doing? Maybe. We apply an objective test. It's highly unlikely. So it wasn't a consideration piece. What was actually relevant there was the awareness. If she hadn't known about that quote unquote reward, the payment that would be made if the product didn't work, she couldn't claim it. Crown and Clark is consistent with the idea that you have to be aware of it. Now, there are also some questions about consideration, and quite frankly, I would suggest that there is a political element in a case like that one. That at the end of the day, governments don't like giving the bad guys large sums of money at the end, so there's a political overtone in there, and I think if we ignore that, we can be a little bit ridiculous about it. But you do have to know about it at the time that you enter into the contract. Because you enter into the contract by doing the thing, returning the lost cat, providing the information. So I'm disappointed in you, Fabian. You've given me a perfect example, which is not what I want. And I would like more of you to come up with ridiculous and silly examples and be completely off.
So therefore there has to be some evidence of the acceptance of the contract.
There needs to be some evidence of the awareness of the contract is the point we're talking about now. And it's probably not a high bar, reasonableness. In Crown and Clark, the parties were not arguing over whether or not he knew about it. The question was just, well, we did these things. Another part of the argument was also, though, around whether or not, and we'll talk about this next week, or the week after, we're going to spend 2 weeks on consideration. There was a discussion about the extent to which the thing was done in consideration of the reward or in consideration of the other promises that were made. So it is a bit jumbled up in that space, but there needed to be some evidence, or at least the parties need to not have an argument about whether the person knew or not. And remember, just because you're not contractually bound to do something doesn't mean that you can't do it. So if I put up a sign on my fence saying reward for my lost dog, and somebody else finds the dog and knows nothing about that and rings me up and I go and pick up that dog somewhere else, I can still be a good person and give them the $50 reward. There's no prohibition against me doing that. They just can't enforce it. If they don't know anything about it until afterwards, they can't enforce it.
So, sorry, Kath, just to clarify, that question there would require the person to have at least been aware of...
Sorry, I'm just reacting to my PowerPoint slide. I'll just...
be aware but still ignorant of...
Yeah.
Right.
Well... No, sorry, let's go back. Because you can't be aware and ignorant at the same time. Well, you can be ignorant as in stupid, but that could go to capacity to contract, but we're not there yet. Let's try and work out where we're up to on this slide pack. It's just having a little meltdown. I knew it was going to be one of those days. So you need to be aware of the offer in order for doing the act that creates acceptance of that offer, for that to create the contract. So you have to act in awareness. And when we look at consideration, there will also be some discussion about whether you also have to act in as a quid pro quo, as part of the bargain. We've got a couple of different concepts caught up in here. No, that's all right. I'm clearly demonstrate to the world that multitasking is not an easy thing to do. So, okay, elements, let's go back. What's the mantra? What are the elements of a contract? Agreement, which looks like offer and acceptance usually, but it might be some other form of consensus. Consideration, for today we're going to call that price. Capacity, that's the ability to enter into a contract, being of sound mind at the time that you did it or being of a certain age. And intention, so an intention to enter into a legal relationship. Which one of those 4 things encompasses something in writing?
No.
So it has to be in writing to reach agreement? No. None of them. It was a trick question. None of them. There is no requirement for the formation of an agreement that something is in writing, unless a piece of legislation from somewhere else says this kind of contract must be in writing. So we'll talk about that when we're in the formalities section. So there's all sorts of pieces of legislation that require writing. For example, the creation or transfer of any interest in land will require writing. If you buy something from somebody who sells door-to-door sales contracts in Australia need writing, a written contract with a cooling off period in it. In Tasmania, if you enter into a contract with a value of $20 or more, it needs to be in writing. That's just a legacy thing from the Statute of Frauds. So there's no requirement for writing. Now, at the same time, writing is a really good idea. Not just because it's going to keep half of you employed. I'm assuming that half of you will be transaction lawyers, the lovers, and the other half will be fighters who will take those documents to court later on. But assuming that half of you are going to go to the good side and be transaction lawyers, you're going to be convincing people to write contracts all the time. And not just because that will pay your mortgage, although that could be one of the reasons that you use, but because writing gives us clarity, gives us certainty. It is much easier when we're having a fight to determine what the parties agreed to if it's written down. But we can make a contract without it being written down. We might have a little bit more issue in identifying what the evidence for that is. In this subject, you don't have to worry about that too much. It's not a stupid thing to point it out to your client that we'll need to ascertain the evidence that supports this, but you don't need to worry about the rules of evidence overly for this course. What we just need to do is understand what the concepts are. Okay.
I just don't feel like it matches up.
Okay, let's go. Let's hopefully go backwards. Let's see if I can do this. Okay, can an act done in ignorance of a unilateral offer be accepted of the offer? So let me use the example in Crown and Clark. Excellent example here. Mr. Clark, in assisting the police with their inquiries, was ignorant of the existence of a reward for the information leading to the arrest and subsequent conviction of Mr. X. Can't remember his name. So the act that he did was exactly what the reward poster offered. Provide information leading to the arrest and subsequent conviction of Mr. X. So he did the act that would otherwise be an acceptance of a unilateral offer to pay a reward. He was ignorant of that offer at the time that he gave that information. So the doing of the act could not be acceptance.
Yep,
Okay. These guys are right. These people are wrong. I have done this too quickly and I've just looked at it. I am wrong. Today is going to shit. And at the moment, I am just waiting for one of these discs to swallow me up. Everybody's happy? Everybody's happy that it makes sense and I'm an idiot. Yeah, I love it when everybody knows I'm an idiot. I'm so sorry. I don't know, everything's breaking for me today and now I'm just making excuses when, the issue is you need to pay attention. All right, so this means that whoever's at the top of the board has got a free ride. So they're just on the same wavelength as me. All right, let's see how many more of these can be wrong. I'm sorry about that. What is the next one? Let's just go to the next one. When is a person who is not the offeree... when can, C for can. When can a person who is not the offeree accept an offer? When the offeror intends that the third party might accept, when the offeree has died, their estate can accept, if the offer states that it can be accepted by a nominee, or when the accepting party acts as agent for the offeree. With only 1 second to go, I tell you more than one might apply. Absolutely all of those were correct. So all you had to do is pick one. All right, opportunity to talk about it. Oh, God, you guys, so thank God it's a long way before you actually have to give feedback to the world about me. So if we make an offer to the world, for example, could be an offer that anybody could accept. Or I could say, I would like to offer anybody in this class the opportunity to proofread my quizzes before I share them. If none of you are interested in this job, clearly it pays $1 million an hour. Maybe you could refer it like to one of your friends, first in, best served. So I've indicated in the offer the one of your friends that a third person could accept it. When an offeree has died, the estate can accept. There are some exceptions to that. So an offer of personal services. So if I offered to write an opera about your life and I dropped dead, you could not hold my estate to that promise by accepting it, because it's an act of personal service that clearly only I am the one with the insight to write that opera about your lives. Clearly, if it says, the first and the third of these are basically the same thing. So nominee is a term we often use. You'll often see it in documents that I'm making an offer to purchase your house. The purchaser will be Fred Bloggs or their nominee. And one of the reasons for doing that is to make sure that you can not pay tax twice. And when an accepting party acts as an agent for the offeree, this is probably even though most people have gone with it, this is probably the least technically correct, because if I am acting as your agent, then all I'm really doing is notifying that you've accepted. So I'm not actually, if I'm your agent, I'm not actually accepting the offer as in becoming a party to the contract. What I'm doing is notifying on behalf of the actual contracting party. But I thought it was too mean to make that a no, especially as I didn't know at that stage that I'd also completely stuffed up the one before. Okay, Lizzie still winning there, but we all know that it's a tainted victory so far. If more than one offeree accepts, but the contract could only be performed once, let's make sure we understand what this scenario is. We've got a contract. It can only be performed once. I'm going to sell you, I'm making an offer to sell this single clicker that I have in my hand, or that single Siamese cat that is in the pet shop. So it can only actually be performed once, but I've made an offer that 2 different people have accepted. The last one to accept misses out. The offeree is likely to be in breach of at least one contract. The offeror is likely to be in breach of at least one contract. The parties will need to go to mediation. So, as a practical matter, the first is often what actually happens, because usually the second person accepting the offer will just believe people when they say, you know, too slow, too bad, so sad, you missed out. But technically, there is a responsibility on a person making an offer to make sure that they don't put themselves in the position where if they're making multiple offers in relation to the same subject matter, that they can't be accepted over and over again, because they do end up in the position where a contract is created by acceptance that they're naturally going to be in breach of at least one of those contracts. So technically correct, commercially most likely, and this one is a mix-up of offeree and offeror. Just making sure you get the language right. Questions, concerns? Oh, Jessie's taken a big leap there. Adding a term when accepting an offer is a really good way to ensure that the terms are clear and certain, creates a counter offer which varies the contract terms, or results in a counter offer extinguishing the original offer. So most people are on the right track here. Again, commercially, the second is quite usual as well, that people who are negotiating swap offers all the time, and the conversation in a negotiation is often a yes and conversation. And in fact, in business school, people all over the place are being taught to have yes and conversations, and it's not being pointed out to them that they might actually lose everything that they've negotiated so far by having that conversation in a commercial context. And that is something I've seen played out commercially a number of times when deals are just getting too long, it's taking too long to negotiate something and somebody really wants to go, that getting a client to hold firm and say, this is our last and final offer, that unless you accept this offer, we're walking away. This offer will not be available to you if you vary it, if you seek to vary it in any way. Sometimes pulling the negotiation to a close in that way. Again, this is not an untrue statement. Adding a term could be a good way to ensure that the terms are clear and certain. Probably you don't want to add a term though. You probably, if you are concerned about clarity, you want to be very clear that you are seeking a supply of information, that you're looking for the other side to explain to you what something means. You're not seeking to vary it, you're seeking to understand. Climbing up there, Billy. Oh, I feel like this should be, I want this person to win because I really like the idea of a contract law rap. And clearly you're a rapper if you've got a Z, or should I say a Z in your name. A court must find both an offer and acceptance in order to determine an agreement. Yes, without both, no agreement can be found. No, it will look to identify consensus and intention. No, offer and acceptance are not relevant if an agreement is signed. Yes, these basic principles are fundamental to the common law. No, that is wrong. Is it wrong?
No, I think it's right. Only because I got it right.
Yeah, I was going to say, is it wrong?
What do we think? Is it wrong? Surely not. We've been spending all this time on offer and acceptance. But what we're actually looking for is agreement. Now, if we've got an offer and a matching acceptance, then we always have agreement. But some of the cases that you read this time round went to what happens when we can't match them up. So Brambles in particular is the one we'll probably spend a little bit of time on, but Air Great Lakes is another one. We're looking at, the courts will use an objective test to identify whether or not the purported, what the parties did and whether or not there is a meeting of the mind, consensus ad idem. So Brambles gives us a really nice test for doing that. I've got a feeling that we won't get to that test today. I'm still working out for weeks where I haven't done desk videos. You're my test model to work out which ones I need to do when I only get 2 hours of class time. So Brambles is one where we've got quite a neat little test that Justice Kirby puts out. But at the end of the day, always look for an offer and a corresponding acceptance first, because that's your easy way to get there. If you can't see that, don't assume that there's no agreement. Look to whether there's a meeting of the minds. And one of the things I say often, I actually even have it on a business card. All my business cards have random things on them. They're all different. But one of them is a little like poster that says, trying to learn how to be a contract lawyer by studying cases is like trying to work out how to be a good parent by only speaking to people who've had their children removed from them. Or trying to work out how to have a good marriage by only speaking to divorced people. Like, both of those things will give you basic information about what not to do, but they don't give you a great deal of information about what to do in the process. So that's why we're constantly thinking, as we think about these agreements or each of these elements, why do we need to know about these things? Now, most of the cases that we'll be looking at, frankly, in this semester are cases where one of the parties didn't want the agreement to be binding on them. Right? They wanted to get out of it, and one of the arguments that they used is there was no contract in the first place. In 99% of contract disputes that go to the courts, whether or not a contract actually existed or not is not an issue. Even if there are issues about the way the contract is formed, the parties aren't prepared to have that fight. It's a tactic in most cases. So we understand how to make a contract by looking at contracts that ultimately failed in court, failed to stand up in court. Am I making sense to you? So we've got to just think about what you're examining here. You're kind of like, instead of deciding whether you like the puppy, you're examining the fleas on its coat. And that's what we necessarily have to do. And it's I often use the analogy of a jigsaw puzzle, that what we're doing at the moment is we're just taking individual pieces for this jigsaw puzzle and we're going to put them down one by one and see how they fit together. But right now, this is a jigsaw puzzle without the box. Like, you don't know what this picture is going to really look like. We've just got these individual pieces that we're fitting together. You sort of have to trust me a little bit on them. So this idea about agreement is an important one, because even though we've spent like 2 classes, one on offer, one on acceptance, actually what we're looking for is agreement. And if you can't find those things, you still might find consensus. There endeth the sermon. And Billy, you got to, did you cheat on that other one too? Did you, not telling?
No, we're not telling.
A written contract is only final when the solicitors have reviewed it. Masters and Cameron, this particular software will not let me italicise. That is a bad citation. Is that true or is it false? I have just realised why I take a drink bottle and a coffee cup, because your water tastes really crappy from your coffee cup. That is absolutely false. So Masters and Cameron, though, is a really interesting decision, and it sets up 3 different types of preliminary agreement, written agreement, and talks about the circumstances in which when parties have reached some form of agreement and written it down, in what circumstances that will be considered binding, even though they intended to write something down or create a written document at a later time. And then there's a 4th category sort of put forward by another case, the Borkham Hills case, which kind of overlaps with the Marston and Cameron cases. So we'll get to that. We'll get to those ideas, but they are really important ideas. But ultimately, although many of us would like it to be very, very different, people can enter into an agreement with writing or without writing, without a lawyer, at any time. Well, a little bit more jostling for position. In order to determine whether parties have reached finality in their agreement, finality is a term that's used in Masters and Cameron, a court will look at whether there's a signed document only, consider the actions of the parties both before and after the purported agreement is made, look carefully at the words the parties used in any written agreement, only take into account what happened before the alleged agreement was made. This one's stumping a few people. So it's actually unusual that because we use an objective test to work out whether there's an agreement or not, the courts will actually take into account evidence of how the parties behaved after the purported agreement was made, because that's evidence of what it looked like they believed at the time. But usually when we're working out whether there's a contract or not, particularly when we're working out what the terms of a contract are, we stop at the point in time when the contract is made, because you can't add new terms once the contract is made. So that's kind of the point there. This is also true, that they'll look carefully at the words that the parties used in any written agreement, but they will look at other conduct to an extent as well. So one of the things that we will explore at great length towards the end of the semester is something called the parole evidence rule. And the parole evidence rule is effectively evidence poker. So effectively what happens is that if you have a written document, it trumps any evidence of a verbal agreement to the extent of any inconsistency between people's statements about what a verbal agreement contained and what's in the written document. So usually we stop at that written document. So if we've got a written document, there's only very limited circumstances when a court will actually look at any other evidence. So I decided to count both of those as being true. So the people who were concerned about the timing of the evidence, this is almost always the right answer. The incorrect answer is almost always the right answer in relation to what period of time do we look at to work out what the terms of the contract might be. Hello, hello, hello. Agreements to agree sound like a good negotiating tactic, are an essential step in the process of creating an enforceable agreement, sometimes make it hard to identify consideration, or are generally not enforceable. So all of these things today are ideas that you should have picked up or could have picked up in some of the readings as you went. So generally not enforceable at all. In fact, usually the only time that we have an arrangement that is an agreement to agree is when there's a very specific process in an existing agreement. So a process that you have to adopt to resolve a dispute or to negotiate a price at some future time. So a term, for example, that says the parties must negotiate in good faith. There could be a breach of that term if parties don't come to the conversations in good faith. The others are, yeah, please.
So in areas of law like native title, where it's a requirement for, say, mining companies to negotiate with traditional owners in good faith to create, like, I know this is
No, it's
like
good.
an Indigenous land use agreement. Say if that, because it's very hard for traditional owners to get any sort of recourse if the company hasn't acted in good faith, like they can go to the Native Title Tribunal, but under contract law, because that Indigenous land use agreement is
a contract.
Could you use contract law somehow to try and
So,
demonstrate lack of good faith?
Some of the reading from the first week would looked at this idea that's being promoted particularly by Professor Finn about whether or not there is an overriding duty in contract to contract in good faith. And I think there are some really compelling reasons why there should be, or that there might be, a duty to enter into a contract in good faith. But it's a jurisprudence question. My own personal view is that that is not part of the law as it stands in Australia at the moment. And I mean, until we have a High Court decision that says otherwise. And the reason that I say that is, again, the harsh light of day. What is contract law for? Contract law is for, ultimately, so that commercial people can enter into commercial transactions in the knowledge that they will be dealt with consistently within a particular political and economic structure. And it is not a crime to not do your side of the deal in a contract. The contract itself will set out, usually, what the consequences are for failing to keep your promise. So it doesn't say that doesn't mean that you're not an asshole if you don't keep your promises. But, if the law was about judging whether people were assholes or not, chances are that all of us would be in jail at some point, right? Or at least paying damages, or at least most of our political leaders would be. So the question is, it's a contract set up a private law for dealing with particular situations. And it's the role of the legislation to come from the outside and provide other softenings, I guess, would be another way of looking at it. So I mentioned before, in the context of when a contract might need to be written down, that door-to-door sales contracts need to be in writing and they need to have a cooling off period. So why do you think that is? Just generally as a matter of policy or principle?
There could be some sort of not coercion, but sort of it's an unregulated kind of transaction.
Well,
one person just come up to your house.
When you've got a consumer who is at home, there's a really famous case a couple of years ago called Lux, where the ACCC and Lux, and Lux basically had a methodology for doing door-to-door sales. What they would do is they basically profiled people in leafy suburbs of Sydney and Melbourne. They basically worked out by the age of their house and how long it had been sold, whether you were likely to be a lonely old person. And they went to the homes of lonely old people. They rang them in advance and offered free vacuum cleaner assessments. Then they would get into the house, they would spend hours there, they had written scripts and all the rest of it. So because they've worked out that most baby boomers who live in Camberwell or Canterbury or Mossman or other parts of the world are likely to be polite and nice people, and they don't like to say no. And if you come in and you have a couple of cups of tea and then you look at their vacuum cleaner and you say, oh, this is terrible, you're likely to get sick from using this vacuum cleaner, you should buy one of our vacuum cleaners. And they were selling like $4,000 vacuum cleaners to these people who really may or may not have needed a vacuum cleaner. Now, these people were not infirm, they were not stupid, they were elderly people who lived in the nice suburbs, and many of them were university educated, they were not ill in any way, but they basically played on their politeness. In fact, they had little rules in there about if it appears that the person doesn't speak English, stay away from them because we'll get into trouble. So ultimately, the ACCC were successful in an action against Lux to say that that was an unfair consumer practice. And part of the set of rules that are around door-to-door sales relate to keeping that practice fair, that recognising that yes, you might be, in theory, we're negotiating a sale, And the theory of contract law works on the basis that commercial people can make decisions. You don't have to enter into a good contract or a bad contract, but once you enter into a contract, then it's going to play out in a particular way. But we recognise in practice that there's very rarely equal bargaining power. Jeannie Patterson, who's at Melbourne Uni, who's the lead author in your text and casebook, she used to be at Mallisons and she was also with the ACCC. She said to me once that in the entire time that she worked at Mallisons in banking and finance, that only once did a client come to the banks with a loan agreement. And that client was one of the big international mining companies. So when you think about it, the bank always has bargaining power. They're the ones who put the contract terms on the table. Do you think that they write those contract terms on the basis that they're going to be fair and equitable and easy on everybody? You know, fair? No, they write those terms to protect themselves, to make sure that they get their money back and that they're protected in relation to all of the things that they need to be protected for. So it's the legislation that then comes in, and those of you who've watched what happened in the Royal Commission over the end of last year and subsequently will see that even then they didn't pay a great deal of attention always. But the legislation comes in and provides for the fairness. So again, good faith, I think you've raised a really interesting question. It's NEO, isn't it? Really, really interesting question. But as a matter of contract law, I think it's very hard to get there. Comments, concerns, frustrations?
Good faith operates in enterprise bargaining agreements as well. Is that
Yeah.
similar,
As a-
similar legislation, similar kind of...
So good faith operates in enterprise bargaining situations, and enterprise bargaining is like collective negotiation for a contract. But then we've got an overlay of some legislative practice that impacts the underpinning of the common law. So again, if you do employment law, and we have one of the preeminent employment lawyers here, if you get to do employment law with Anthony, you are going to learn from the absolute best, particularly if you're interested in enterprise bargaining and industrial relations stuff. But that sits on these fundamental principles. Sorry, we're taking rather a long time to get through the quiz today, but I'm getting to talk to you about the things that I want to talk to you about, so it's not going to worry me if it doesn't worry you. Silence is golden. However, alone not adequate to be acceptance, and can represent acceptance if an offer stipulates that it's an appropriate method. I think I might stand down the back here for a minute. I feel like I'm... Of course, actually you've set up the front so you can hear me with my big boomy voice. So silence alone is not adequate for acceptance. So if I say to you, this magic clicker that I'm so happy with, that allows me to highlight things on the screen and stuff like that, that I will sell it to you for $150,000, and if I don't hear anything from you and to the contrary by Tuesday, I'll be expecting the deal to go ahead. And you don't do anything, say because you really want this clicker for $150,000, why wouldn't you? It's awesome. I would not be able to sue you on the basis that we had a contract. I would need you to do something more, not a lot more. Could even be just nodding your head when I said it. Could be the thumbs up sign. Could be anything, but I need something more than just silence. So why is that? And if extra points for giving me a case. Sorry? Feldhaus?
The architect.
Are you thinking of McMahon?
The developer said that he doesn't do contracts.
The developer doesn't know. That is an interesting case on a slightly different issue, but No, I'm thinking about one of the horse cases, actually.
Oh yeah, I can't remember what it's called, but someone was selling a pony or
Yep.
considering selling it, and then they said, if I don't hear back from you, I'll consider it sold.
Yep.
Or something like
So
that. Or sold or something like that.
Feldhaus and Bindley, I think it is. I'm very bad at remembering case names too. Luckily, we don't actually. By the way, it's, you know, you're not rewarded in any law subject for your memory. You get to go to everything with your notes. So Feldhaus and Bindley, effectively, and the nephew is selling a whole lot of stock equipment and stuff. The uncle writes to him and says, I want that particular horse. I'll offer you whatever it is, $1 million. And if I don't hear anything from you, I'll consider it yours. The nephew had every intention of selling it to him. He was happy with that deal. And he even said to the auctioneer, keep that horse aside. The horse, the auctioneer didn't keep it aside. And then sold it. There was actually another action that had been brought first in tort against the auctioneer. So the next action came again against the auctioneer in contract based on the auctioneer being the agent. And if the contract had already been made, then the agent actually had no authority to sell this horse because it was no longer the property of the nephew, effectively. So the question became, was the horse still the property of the nephew? The answer was only no if a contract had been made between the uncle and the nephew. On a subjective basis, the nephew had every intention of selling it to his uncle. The offer was made, if I don't hear anything from you, I'll consider it mine. But the court found silence alone was not enough. So what's the good that comes out of that? Why would a court decide when two perfectly rational parties have made this decision between them? Why would the court think it's a good idea to say, well, actually that act of not doing anything was not sufficient acceptance?
Because anyone could just make a contract.
Anyone could just make a contract and...
I could say, if I drink this water bottle, the Australian government has to pay me $1,000.
Exactly.
Like,
So we would presumably need to have, we still need the other elements. The Australian government would need to know about that, and also consideration would need to kind of go both ways. But you're absolutely right. We end up with chaos unless we have some sort of act of acceptance. We just don't know what the situation is, and you can't know for sure. So if I send you an email, this is I know this case was way before email, but so maybe I should use letter. If I make this offer, silence with a letter, and the letter gets to you, but you're busy selling all of the equipment on your farm, you haven't got around to opening your mail, you have received a letter with that offer in it, which says, if I don't hear anything from you, I'll consider it mine. Technically, you've received it, you're not even aware of it though, and I win. That would be a ridiculous result. Oh, little adjustment at the very end. I think that was my last question. And if it's not, I'm going to suggest that we have a 5-minute break anyway, so that we can get on to some other content. All hail Billy, even though I suspect with this stunning result that he may have had to have got the one that I got that wrong. But if he didn't, even better.